Hi, good evening, everyone, and welcome to another edition of our Justice and Peace's guest speaker series. Today's guest is going to talk to you about immigration law and his practice and a lot of changes that are happening. And so, thank you so much, Arian Sultafa, for joining us here today.
Good evening, good afternoon, everyone. It's a pleasure for me to be here and share, I'd say, my knowledge and my experience with you tonight. As your instructor noted, my name is Arian Sultafa. To just give you a little bit of a background about myself, I'm a regulated immigration consultant, have been practicing in the area of immigration services, immigration law since 2001, 2. So it's been about almost 20 years now. And in terms of my experience, I'd say, expands to various areas of immigration law, family class, all types of applications, temporary residence applications, which includes visitor visas, work permits, study permits, and part of the work permits as well, LMIAs and TRPs as well. And also, I'd say, economic and business class applications. And a big part of my work as well is representation as counsel before the IRB on all divisions of the IRB, which is Immigration Division, Immigration Appeal Division, RPD, Refugee Protection Division, and RAD, Refugee Appeal Division, on all types of matters before those divisions. And that will also be part of me touching upon tonight in terms of the changes that are coming in that area. By way of a background, I also have a Bachelor of Laws from back home and Bachelor of Sciences, and also graduated in the Immigration Practitioner Program at Seneca College. My, I'd say, involvement just recently, since this is, I'd say, quite a new thing that is being implemented with a specialization program for counsel appearing before the IRB. During the period of February to April this year, I also served as a subject matter expert with the ICCRC in designing the new specialization program, and particularly my involvement was with RPD and RAD, Refugee Protection Division and Refugee Appeal Division. And currently, I am an instructor at the new graduate diploma in immigration and citizenship law program at the Faculty of Law at Queen's University. Have also done quite a bit of, I'd say, instructional work in CPD programs for regulated Canadian immigration consultants and other, I'd say, activities relating to that in the area of immigration law. So tonight, I think we will focus on, now, Jean-Paul, do you want me to share my screen so I can do a little presentation?
Yeah, I mean, maybe that'll be a great way to kind of kick things off. So I think you should be able to share.
I think I should be able to, because I checked before and I was allowed to do that. So just give me 1 second here. Okay, so my presentation tonight mainly is focused on the IRB, but by all means, as Jean-Paul, your instructor, noted before, we can touch other areas of immigration and changes that are expected in the area of immigration law and policies other than the IRB as well. First, let's, I think, get going with the IRB itself. But before getting here, since Jean-Paul mentioned, I'd say, either immigration laws and policies or areas of immigration, overall, immigration is, I'd say, made up of 3 pillars, which is economic class of immigration, family class, and refugee resettlement. Now, what each of them consists of: economic class immigration, basically this is the immigration practically that we want. It is merit-based, selected on the credentials, on the qualities, on the criteria, on certain criteria of the candidates, and each programs that fall under economic class. And as you may have heard, perhaps some of them fall under express entry as well, are programs that are designed to measure the individuals or the potential candidates who are aspiring to immigrate to Canada based on certain criteria, based on, I'd say, on their skills and abilities and education and age and language ability and so on and so forth, to be a driving force, the fuel for the Canadian economy. Between the three classes or pillars of immigration or classes of immigration, there have always been, I'd say, some sort of friction, so to speak, or allocation of quotas as to which one will make the most part of the overall immigration that we do get in the country. And as it is now, economic immigration, which also includes business class as well, individuals who apply under any of the business categories, such as startup visa programs and others. Also, our economic immigration takes the biggest chunk of it, normally anywhere between 55 to 57%. And then we have the family class, the other, I'd say, pillar of immigration, which is based on not, as we noted before, on the economic class. They are selected, or that group of individuals are selected based on certain criteria, based on certain qualities as to coming to the country and being able to be the driving force for the Canadian economy. And the family class is selected strictly based on a family relationship, based on a relationship of the foreign national, of the applicant, so to speak, with the Canadian sponsor. And so we have different various classes of sponsorships, which is dependent children, spouses, common law partners, or conjugal partners, parents and grandparents, siblings to a certain extent as well, and also nieces and nephews, again, with certain limitations. And then the other pillar of immigration is refugee resettlement, which is made of two, I'd say, big groups in itself. One of those will be, or is, the inland refugee determination system, which means individuals who are already in the country and who make a refugee claim here in Canada, either at the port of, and so this can be done either at the port of entry or at the inland office, at an inland IRCC office. And then we have the refugee resettlement program, which I'd say, once we mention that, we are seeing this firsthand, I'd say, laid out and in action, in movement with what's happening now in Afghanistan. So that is basically I'd say, the humanitarian spirit that Canada has always had in extending a helping hand to the people, to the individuals who are in desperate need of protection all over the world. So the difference, I'd say, between the two is that, and it kind of relates with what the next part of the presentation will also be with the IRB. It relates to who decides what on that group. And so the ones who are already in Canada and who make a refugee claim at any port of entry or inland, they are subject to being decision-making by the IRB. So they will go and they will have a hearing. First of all, before we get to the hearing, there will be an eligibility and assessment in terms of whether there are any obstacles to their eligibility for making a refugee claim, and then looking at the eligibility criteria. And then once it has been determined that they are eligible, then they will be referred to for a hearing at the RPD, Refugee Protection Division. Then the other group, which is outside of Canada, which is now we see in action with what's happening in Afghanistan, I'd say the department that is responsible for that is IRCC. So it is the visa offices or high commissions outside of Canada. So it's an application like any other types of applications which is made, and then A visa officer overseas will be the one to assess, determine, and grant permanent resident status to a foreign national who is applying under that category. Now, on the IRB itself, or John Paul, if you want, maybe to, if there is any questions, or we leave the questions for the end and I move on with the rest of it. What do you think?
Yeah, maybe we can just take the questions all at the end. That way you can go through everything.
Okay, perfect. Okay, so that first of all, I understand that you are a paralegal class, which will fall under the purview of the Law Society of Ontario. And so the Law Society will be your regulator. But on the immigration side, there is also, and a lot of you may have, I'd say, dual license and may have chosen to also become an ICCRC, a member of a regulated Canadian immigration consultant, for the very reason that there is a distinction in terms of the scope of practice as to what the Law Society will allow you, one of which is representing clients at the moment before the IRB, but then with a IRCC not allowing you to do immigration work and represent clients in any types of immigration matters applications, what I noted before on any of the three classes of applications. Now, on this, I'd say, side here on the IRB, there are also recently big changes that have been implemented. And the other thing on the ICCRC side as well, there are big changes that are in the process, and ICCRC itself, as it is, as a regulator for immigration consultants, now it is on a transitional stage to turn into a college of immigration and citizenship consultants, which will come into effect come this November 23rd, 2021. And so now this is a higher, I'd say, stage or higher means of regulating the profession by an act of parliament. And as such, the requirements have become more stringent. And as part of that is also that new graduate diploma program at Queen's Law, which now is the only one for the English-speaking individuals who can, I'd say, deliver that program and allow you to become an immigration consultant, and University of Montreal on the French-speaking side as well. Other than that, there is also this new specialization program, which I will touch upon a little bit later once we start with the IRB itself. So I will try to give you, I'd say, a highlight, an overview of the tribunal, which is the one and only immigration tribunal that hears and decides immigration and refugee related matters. One second here. Okay, so what is the IRB in itself? So the IRB is a federal quasi-judicial tribunal that reports to Parliament through the Minister of IRCC. So in other words, the purpose or the very rationale for having, and this basically was created based on Singh decision, I think 1985, Supreme Court of Canada Singh decision, but the very reason for implementing this, I'd say, a tribunal is to create independence and to impartiality of decision making, and so to make or to have a deciding body that will operate at arm's length from the government, but it's not, I'd say, in any way dependent and related to the government itself. So free of any political, I'd say, interference in itself. So the immigration division consists, the IRB, Immigration and Refugee Board, consists of 4 divisions in itself: Immigration Division, Immigration Appeal Division, Refugee Protection Division, and Refugee Appeal Division, which is I'd say, the newest division of the board. It was implemented on, if I'm not mistaken, December 15, 2012. So it's been in operation for about 8 years, 9 years so far. And initially, I'd say there wasn't much, or there was none, I'd say, case law as well in terms of federal court or higher courts relating to RAD. But now, as it has been in operation for 8-9 years, the case law has also developed, and the scope and the jurisdiction of the division has also been well established as well. So in terms of the structure, we have the chairperson, who is practically the CEO of the organization. And then we have each of the divisions, who are run and managed by a deputy chairperson. And then we have the administrative staff and the coordinating members and the members, who also are the ones who make decisions on immigration and refugee related matters. Now, if it may be, because this all falls under the area of administrative law, so that's why it is quite important for you to understand, and also firstly understand the principles of administrative law, and so that way then you can pretty much are able to understand how each of those tribunals will function, whether that is a federal tribunal, which is the IRB in our case, or it's a tribunal, a provincial tribunal, the ones that you will also be or have be part of scope of practice for you to represent clients as well. Now, in terms of who appoints what, depending on the, I'd say, the ranking of the division itself, they are public servants or governor in council, cabinet, basically appointees. And so, to make it easy and simpler, the ones who are the appellate divisions, which is RAD and Refugee Appeal and Immigration Appeal Division, they are appointed by the cabinet, by the governor in council, and Immigration Division and Refugee Protection Division are public servants. Now, in terms of who makes decisions at the IRB, we have the deputy chairperson, assistant deputy chairperson, and members, coordinating members and members. And then we have the admin staff, who are there to assist them in their duties. So the chairperson is, as we noted before, the CEO of the organization. And so as such, he is vested with the task or the duty to oversee, supervise, and direct the work of the board. And if you see here some of the duties of the deputy, of the chairperson, and these are duties that can also be delegated to assistant deputy chairperson, to the deputy chairpersons for each of the divisions. But one thing here that stands out, and it's important, is that the chairperson of the IRB is also the one who is or has the authority to make the rules for each of the divisions. And so this is the only, I'd say, authority or jurisdiction which cannot be delegated, and only the chairperson himself or herself is the one to exercise this authority. Now, what this means is that these are basically the rules of practice, and as a matter of how they function or perception, each of the divisions is meant to be, or I'd say, put in place as being able to or considered to be masters of their own house. And so as such, each of the divisions have their own set of rules in which counsel appearing before the IRB needs to be familiar with. So in other words, what it means in overall, you as counsel representing clients before the IRB, is that other than knowing, I'd say, the case itself and doing the preparation for yourself and for your client, and submitting the evidence in accordance with the rules of the division and the disclosure as well, it also matters that you know the how-to part, how the hearings are conducted on each of the divisions. And don't take it for granted that just because you know one, the other one is going to be the same, because each of them, like I said, it's considered master of its own house and has its own set of rules. And so you need to be familiar with those rules before you appear to any of those divisions. So in terms of the authority, the powers that the members will have, the Immigration Division, Refugee Protection Division, and the RAD members have the authority and powers of a commissioner appointed under the Inquiries Act. So they have the authority to summon witnesses, to administer oath, take evidence. And then we have the IAD, and members of the IAD actually have, or IAD is considered as I'd say the same authority as with the Superior Court of Justice. And so they have the authority to swear in and examine witnesses, order the production and inspection of documents, and enforce its order. So when we say it has the authority or it has jurisdiction the same as the Superior Court of Justice, it also tells you that the level of formality there is quite different from also Refugee Protection Division or Immigration Division, or RAD in itself, which mostly conducts hearings in writing. On the overall, even though I have not mentioned it here, but since we got to this point here, in terms of the hearing formats, we have what? We have oral hearings, we have electronic hearings, and we have written hearings as well. So the RAD is the only division that mainly conducts written hearings, which means that you prepare the file, you prepare the application, the appeal, or the application record to the division, and prepare your memorandum of facts, law and facts as well. And so then you submit it, and the RAD member will be the one to make the decision based on what has been presented in front of him or her. So members have, or are the ones who basically conduct the hearings and manage the hearings and the hearing flow as well. And so they have the authority to administer evidence, to take oath, and to designate a representative for a minor or incapable person. In other words, for someone who is not able to appreciate the nature of the proceedings because of whatever reasons, young, minor children, or even adults or elderly, let's say with memory loss or any types of situations which make them not able to understand the nature of the proceedings. Then they have the authority to also decide on the hearing. They decide whether the hearing on the hearing that has been, to declare a hearing abandoned. And so that is when someone has received notice but does not appear, or to withdraw the case, and they make a decision on that as well. And also to make a decision on the hearing itself as to the merits of the case at hand, and whether to, if it's a refugee, let's say, appeal or immigration appeal, allow the appeal or not, or to I'd say refuse, or in a case of a refugee hearing at the RPD, grant the individual the protection as a convention refugee or a person in need of protection, or deny this or refuse basically their refugee claim. So here is what IRPA section 91.1 states in terms of who is authorized counsel before the IRB. And so as it is now, a lawyer who is a member in good standing with the Law Society of a province or a territory, or member of Notary Chamber of Quebec, any other member in good standing of a Law Society of a province, which now includes paralegals, and also member in good standing of a body designated by the minister, which currently is the ICCRC, and come November 23rd, it will also be the new College of Immigration and Citizenship Consultants. So what's new here now in terms of the ability of counsel to represent clients before the IRB, this is, I'd say, the new change that has been implemented. It was in the works for the past few months, and so now they have launched it just maybe 2 or 3 weeks ago, not that long ago. And so with the launch of this program, basically now, I'd say appearance or representing clients before the IRB come July 1st, 2022 will become a restricted area of practice. And so this new specialization program basically is a way to verify the educational and competency of counsel appearing before the IRB to ensure that clients get, I'd say, adequate service and proper quality of service as well. So what basically, and so there is no exception to this, I'd say, rule, and only the new, or I'd say the new, yes, the new graduate diploma program students from Queen's University or University of Montreal will be the ones who will not need to go through this. But keep in mind that the program only started in January of this year, so no one has come out and is graduated from those programs yet. And so those programs are actually quite lengthy in the sense of it's either a part-time or a full-time programs. At least Queen's University has it part-time or full-time, and it will be either a 1 year or a 2 year program, depending on whether you take it full-time or part-time. Now, how it applies or how it relates to you as paralegals, basically ICCRCs are CICs, regulated Canadian immigration consultants, who are paralegals. In other words, members of the Law Society of Ontario are required to complete the specialization program and pass the specialization exam to obtain the IRB class of license. In other words, when you appear now before the IRB as of July 1st, 2022, you will not be allowed unless you have the IRB class of license. Now, for those of you, because in here, ICCRC, of course, has authority to the part of the ones who are members of the ICCRC itself, or the new college come this November 23rd. So the other part are the paralegals who are not members of the ICCRC. That remains to be seen whether the Law Society, because they are regulated by the Law Society, and that remains to be seen whether the Law Society will implement anything like that, or it will be something like paralegals working under the supervision of lawyers, and so as such might still continue and be allowed to represent clients on the IRB proceedings. But that remains to be seen. This is something that, like I said, it was just implemented, and we will see how this will evolve in the future as well. So in terms of how you get this specialization license now, there are 3 pathways. Keep in mind that ICCRC itself has a large number of members who are licensed to represent clients in immigration and citizenship matters. And so as such, it also recognizes, I'd say, the degree of knowledge and education and experience and expertise that each of them may have had in representing clients in the past with the IRB as well. And so as such, it has created, I'd say, 3 pathways to try to accommodate all, I'd say, types of situations that each of the members might fall into or think that they fall into. And so they need to then pursue each of those pathways to get the IRB class of license. Sorry, keep in mind that this is not mandatory. What this means is that ICCRC members will have practically it will be a 2-tier system or 2 classes of license. So it will be the ICCRCs as we know them now, who can do anything in terms of immigration matters and also representing clients to the IRB. But after July 1st, 2022, this will be a 2-tier system, which means the ones who do not have the IRB class of license can still continue to do immigration work and do immigration applications and represent clients with the IRCC or CBSA in any types of matters. What they cannot do is represent clients in the proceedings with the IRB in any types of hearings before any of the divisions. And so depending on the interest, like I said, this is not mandatory. If someone who has no interest in representing clients with the IRB may not pursue this, or someone who does want this may go ahead and do it. So in terms of the pathways, we see here that there are 3 main pathways, which is the education pathway, taking the entire basically program, specialization program with the ICCRC. and that is for 18 weeks, and it is made up of 5 modules. With it's the foundation of the IRB, its foundation, then each of the divisions, foundations of the Immigration Division, of the Immigration Appeal Division, RAD, and the RPD. Then we have the pathway number 2, which is the Prior Learning Assessment and Recognition, PLAR pathway. This group is, or this, I'd say, pathway is for those individuals who do have experience representing clients before the board and do have the knowledge and have or are able to demonstrate this knowledge by creating a portfolio. And so that portfolio in itself actually was quite a daunting task in terms of what was required to be put in there in terms of, and so you need to do all the education side of things, and then any representations before the board, and how you deal with clients, and the quality of service, or how you make yourself, how you gather the information, interviewing your clients, how you communicate, I'd say, the outcome, or how you communicate the likelihood of success or non-success to clients in a particular case that you would be representing before the board. So it was it based practically is a lot of work to put together to submit to prepare and submit this portfolio. And then we have the hybrid pathway. And so what the hybrid pathway means is that on the PLAR pathway, you can require recognition on all of these, or you can go the hybrid pathway. So let's say there might be people who maybe just did representation before the Immigration Division and did focused on, let's say, detention review hearings. And so you in the hybrid pathway, basically or practically, you are seeking recognition on one or more of those divisions that you intend to represent clients from, and then take the course or take the education pathway for the rest of them. So then we get into, I'd say, a little or a brief highlight of each of the divisions in itself to give you as to what types of hearings each of those divisions hear and decide, types of matters those divisions hear and decide. And so that way it opens up, I'd say, a little window for you to also be aware as to perhaps try to identify and pinpoint your interest in the future as to whether you want to do any IRB work or board work or not, or focus on different areas of law, being a paralegal, or perhaps when you become, or if you become an ICCRC member as well. So here we have the types of hearings that we have at the Immigration Refugee Protection Division. And so what the Refugee Protection Division hears and decides refugee claims made inside of Canada, as I noted, either in the port of entry or inland. And so then once a claim is made, is referred to the RPD, then there are screening officers in there that will identify the issues and try to, I'd say, then organize or put files depending on how complex they are or how least complex they are. So that's why we might have short hearings or expedited hearings or full day hearings, half day hearings, depending on the complexity of the case. With that being said, that doesn't mean that those are set in stone, in the sense that, let's say, if your hearing was scheduled for half day hearing or less complex hearing, and there are quite complex issues that do come during the course of the hearing, then it may turn into a full day or more than that, and it can extend to more time as well. So hearings at the RPD, due to the sensitive nature of those proceedings, are held in private, are recorded, are held in English and or French, and interpreters will be available if one is needed as well. And so these are the types of hearings which we call inquisitorial hearings, so non-adversarial. So when we get into the other. So let's say when we get into the immigration division or when we get into the immigration appeal division, we will see that those are adversarial hearings. So you have U.S. counsel for your client representing your client, and you have on the other side the minister's counsel representing the immigration and citizenship department, the minister, in other words. So in here, at the RPD, the member takes an active role, and so he or she is the one to inquire and ask questions and try to get to the bottom of it for the purpose, I'd say, with the truth-seeking purpose. And so based on that, then you will, as counsel as well, you'll have your right to ask questions and try to make your case. And based on all of that, the member will be relying on to make a decision as to whether the refugee claimant is or is not a conventional refugee or a person in need of protection as per section 96 or 97 of IRPA. So here we have I'd say the how-to part, the rules of the division in terms of the conduct of the hearing, which is Rule 10. And I did address it before in terms of inquisitorial process in which the member will ask questions. So the member is the one who asks questions first, and then the claimant will answer all those questions truthfully, directly, or through an interpreter if he or she doesn't speak English or French. And then the claimant's counsel will be the one to as well ask questions. And once the hearing is concluded, then the counsel will be in a position to make the final arguments, the submissions. And so those submissions will be either in writing, oral, so you can do it right there and then on the spot as well. So the rights that are, I'd say, vested or lie with a refugee claimant, they have the right to counsel, they have the right to interpreter, they have the right to present, basically make their case, they present evidence and call witnesses. So always in those cases, you need to know the onus, the burden of proof, who has the burden of proof. And so in this case, the party that has started the process, made a refugee claim, has the onus or the burden to satisfy the decision maker that their claim has merits, and so as such, they are deserving of being granted conventional refugee status or a person in need of protection status, either under 96 or 97, section 96 or 97 of IRPA. So in here, they must provide credible and trustworthy testimony and meet that threshold, meet the burden of proof, which is more than a mere possibility, more likely than not. So in terms of then what happens once the hearing is concluded, the decision maker, the board member, always keep in mind that the hearings basically at the RPD or any of the divisions, the members are called members. We do not address them as Your Honor, as you may have seen in courts or in the movies in courts as well, but as members. And it is important to know that as members or by their last name as Mr. or Madame this and that. And this is important as well because it shows you, I'd say, shows knowledge and familiarity with the setting and with the division itself as well. So once the hearing is concluded, the division or the member will make a decision, and the hearing, and if I'd say the member is in a position to make a decision right there and then on the spot, they will make a decision right there and then on the spot. If not, they will reserve their decision and then provide the notice of decision and reasons for the decision in due course. What might happen, the scenarios and what comes after, they are more like, I'm going to give you a little bit of highlight, but they are more like in terms of a more in-depth as to what comes next. But if they get a positive decision, basically they will get the decision stating that the refugee claimant before them is a conventional refugee or a person in need of protection. And so after that, they will be able to apply for permanent resident status as a conventional refugee or a person in need of protection. Or if they get a negative decision, then what they need to do is they need to assess. I'd say in a nutshell, they need to assess first, because what comes next is RAD. And so they need to assess whether they have the right to appeal, because not every single failed refugee case will have the right to appeal. So first they assess whether they have the right to appeal. If they do, then they apply, file an appeal with the Refugee Appeal Division. And if there is no right to appeal, then the next, I'd say, step or the only recourse will be judicial review at the federal court. Now, in terms of the hearings that the RPD hears and decides, the matters that RPD hears and decides, as we noted, we have refugee claims, and we have also cessation and vacation claims as well, matters as well, that are heard and decided by the RPD. So on the outcomes, as I noted, you can get, depending on what you get, you can apply for PR, or then you look at the next step. Now, if the claim is rejected, you look at the eligibility to make a claim, to file for appeal at RAD, Refugee Appeal Division. And so here you have types of situations in which there is no right of appeal. In other words, the only recourse will be judicial review at the federal court. So if the member makes a finding that there is no credible basis for the claim, or if the member makes a finding that the claim is manifestly unfounded, or if the claim was declared abandoned or vacated. So there are other situations as well in terms of when assessing eligibility to file for appeal. Now we look at the appeal divisions, which is the Immigration Division, Immigration Appeal Division and Refugee Appeal Division. So they have the sole and exclusive jurisdiction to hear and determine all questions of law and fact, or mixed law and fact, in the proceedings that are brought before them. They make their decisions on any evidence that has been presented and put before them. They are not bound by any legal or technical rules of evidence. So here is the distinction, I'd say, between the tribunals and the courts in terms of their less formal on the rules of evidence. They may grant a remedy that if they determine that the lower division is wrong in fact or mixed law and fact. And they also have the authority to RAD, when we look at it as well later on, that they can substitute. They have the authority to substitute the decision of the RPD with their own. And they are not required to hold an oral hearing in every circumstance. And as I noted to you before, mainly 90%, I'd say, if not more, of RAD hearings or cases are written. And in certain, in special, or I'd say in special circumstances, they may hold oral hearings, and U.S. counsel may always ask, but you need to provide, I'd say, arguments as to why, especially when the credibility is at issue, why you need an oral hearing for the case at hand. So IRPA itself, Section 74 of IRPA sets out as to the right of appeal. And so we will see that in immigration proceedings, and so now apart from the IRB itself, we will also see that in any type of immigration proceeding, we look at IRPA as to whether there is or there is no right of appeal for that particular matter, for a refusal that we got in a particular matter, whether that is a visitor visa or family class sponsorship. And so if there is right to appeal, then we apply and make an appeal to Immigration Appeal Division in that case. Or if there is no right to appeal, then the only recourse remedy will be a judicial review at the federal court. So always, I'd say, be mindful, be familiar with the rules of each of the divisions so that you can, I'd say, present your client's case as counsel in the best way possible and advance every and any argument within the boundaries of the law on your client's behalf. So here we get into the Immigration Appeal Division in itself, which I will give you a little bit of a highlight as to what it does and what types of hearings or matters hears and decides. So we always, the four types of hearings that the Immigration Appeal Division hears and decides are the sponsorship appeal, so sponsoring a member of the family class, removal order appeal of a decision of the Immigration Division in an admissibility hearing, removal order appeal of a decision made by an Immigration Division during an admissibility hearing. So basically, this is in one: removal order appeals. We have residency obligation appeals, and then we have minister's appeals. All of these are as per section 63, and then we see the right of appeal 63.1, 63, 2, 3, and 4 as well. Now we have also, in terms of the, I'd say, the process in itself, we have the timelines for the appeal, and then we have the timelines that the Immigration Department will have to provide the application record, to provide basically the full details of the application at hand, their disclosure, in which then you will work on to build your case and your appeal at the Immigration Division. So here we have either 30 days or 60 days for the notice of appeal, and that depends on where the party who has the right of appeal is located. So if the party who has the right of appeal is in Canada, they only have 30 days to file the notice of appeal, and if they are outside of Canada, they have an extended period, which is 60 days to file the notice of appeal. The same way for the appeal record, the minister, depending on where the application at hand is, will have either 45 days or 120 days. So on a sponsorship appeal at the visa office outside of Canada, it's 120 days. A removal order appeal, those are decisions that are made inside of Canada, 45 days, or minister's appeal as well, 45 days. And residency obligation appeals, it's outside of Canada. It applies to situations in which a permanent resident outside of Canada is applying, basically has no valid PR card to travel back to Canada, and so they apply for a permanent resident travel document. And so at that point, an assessment is made by the visa officer outside of Canada as to whether they have met the residency obligations, or there are enough humanitarian and compassionate grounds to warrant the special relief and grant them the permanent resident travel document to be able to come to Canada. So that is an examination in itself. And so since that is occurring outside of Canada, then the party has the right to file for appeal within 60 days. So in terms of the proceedings before the Immigration Appeal Division, proceedings may be in all, I'd say, formats. It can be an electronic hearing, it can be, and nowadays actually all of them are electronic hearings, are done through MS Teams. But even in normal circumstances, they can be oral, written, or electronic, or within the same hearing, you may have a combination of more than one. Those hearings are held in public. So you see here now the difference with RPD, in which the hearings were private. So the hearings here are public, which means you can at any time go and observe, assuming that the normality will resume soon. You can go and observe hearings at the Immigration Appeal Division and try to, I'd say, master your skills and ability to represent clients at the division as well. Hearings are recorded, are held in English or French, and the key distinction, again, these hearings are adversarial. So you have the other side, the minister's counsel, who is there to represent the interest of the minister on those proceedings. Now, who is present there? Of course, the member, the decision maker, who will be the one to make a decision at the conclusion of the proceedings. Interpreter, if one is required. The appellant, your client, you as counsel for the appellant. Then you have the other side, the minister's counsel, and you have witnesses as well, which you may have called. And depending on whether there is a need for such or not, then you might also have a designated representative in the same way as we noted before, if the party itself is not able to understand the nature of the proceedings. So the IAD, as we mentioned before, is the only division that has all the powers, rights, and privileges that are vested in Superior Court of Justice. And members are not limited to reviewing evidence because hearings are de novo. This is a key concept as well. So a key distinction, let's say, when we looked at Section 63 of the Act as to the right of appeal and whether a particular case has the right of appeal or not, let's say to the Immigration Appeal Division, is that hearings at the Immigration Appeal Division is a hearing de novo, which means it's a fresh start. You can, regardless of what it was submitted on the application to the Visa Office or High Commission outside of Canada, you have now the ability to fix everything and provide any new evidence or any evidence that was available but was not provided at the time of the original application. Versus federal court, first, which only lawyers have I'd say it falls within the scope of practice of lawyers, but also a key distinction is that it relies on the record. It relies on the application that was originally submitted with the Visa Office or High Commission, and no new evidence is submitted on judicial review. So this basically gives you a fresh start, an opportunity to fix things, and even more so now because you have and of course, when you get a negative decision, the very first thing, perhaps not even waiting until you get the application record, is to apply for ATIP and get all the notes and records on the side of the immigration officer as to what led him or her to, I'd say, refuse your client's application. And so that way now you have way more information as to what the issues are in there, what I'd say, what the red flags, what the potential red flags were there for the officer to make him or her refuse the application at hand. So that way you have the opportunity to address those concerns, fill in all of those gaps that were noted on the original application, and put a proper application before the Immigration Appeal Division to allow the member to making a decision that will be favorable to your client's interest. So the decisions are rendered orally or in writing. And the decisions orally generally are at the conclusion of the hearings. So the member, so now what are the possible outcomes here? The member may allow the appeal based on an error in law, fact, or mixed law and fact, based on breach of principles of natural justice, or taking into account the best interests of a child or humanitarian or compassionate consideration. So one key thing here on the Immigration Appeal Division is that Immigration Appeal Division assesses and looks at the matters on errors of law and fact or mixed law and fact, but they also look at it on equitable grounds. And so what that means is that, let's say, if I can give you an illustration of as to what that means. Let's say you have an individual who has been outside of Canada, permanent resident, has been outside of Canada for an extended period of time, and his or her PR card expired. So now they are applying to for a permanent resident travel document to come back to Canada. Now, there are two ways to do it. One is to submit evidence that you have met the residency requirement, or the other option is, if you know that that's not the case, the other option is to pursue it on equitable ground, on humanitarian compassionate grounds. So the same here at the Immigration Appeal Division. You can pursue it if you, let's say, got a refusal at the visa office outside of Canada, and you know that you have not met the threshold of residency requirement, then you can pursue it on humanitarian and compassionate grounds as to where I'd say, and in those, then you look at case law as well as to by how much you are short of, what is your establishment here in Canada by by how long have you been staying outside of the country? How established you are here? What was the original reason for leaving the country? Any attempts that you have made to return? When was the first attempt to come? Any factors that prevented you from coming to Canada? So all of those, and also how you losing your permanent resident status may affect other individuals as well. So in other words, hardship to you, but also hardship to others, including children who may be directly affected by such a decision. So depending on the types of appeals, we also have, let's say on a removal order appeal, we have the board member may stay a removal order or may dismiss an appeal or declare the appeal withdrawn or abandoned. Or the minister may as well allow on consent if the minister is satisfied based on the evidence presented that there are grounds to allow the appeal. And the member as well presents the reasons for such a decision. On the refugee appeal division, as we noted, I believe at the very beginning, this is the newest division of the Immigration and Refugee Board, which was established on December 15, 2012. And this is an opportunity now for failed refugee claimants to establish that the RPD decision was wrong in fact, law, or mixed law and fact, or on the merits of the appeal as well. The hearings here, as I noted, almost, if not more, 95% of them are written hearings. Only in exceptional circumstances that the RAD may allow for an oral hearing, and appeals are decided by a single member. So on the right of appeal, we again look at eligibility, look at whether the failed refugee claimant has the right of appeal or not, which we mentioned before when we dealt with the Refugee Protection Division. And of course, if there is a right of appeal, so in other words, the key thing here is that you're not allowed to skip or to bypass and do whatever it is that you want. If there is the right of appeal, then your only option will be to file an appeal with RAD. And if there is no right of appeal, then you can go to the federal court for judicial review. But if you have the right of appeal, you cannot choose and skip it and go to federal court and file judicial review unless you have gone through the RAD process first. Here you have the timelines as to filing the notice of appeal. Again, for all of it, my single advice to this will always be to look at the rules of the division, each of the divisions that you are going to, because the rules clearly set all of those in terms of steps and what you need to file and when, and then the supporting evidence to perfect your appeal as well. So you file the notice of appeal within 15 days from the negative decision, from the date you receive the negative decision. Then you have 30 days to perfect your appeal. And so in that perfection of appeal, you basically include in there all the documents on which you relied to during the hearing and all the transcript, new evidence that you have. RAD also allows you to submit new evidence. But again, there are special rules as to when and in what circumstances. So it's not a hearing de novo per se, as we mentioned on the Immigration Appeal Division, but there are, I'd say, requirements as to when new evidence will be allowed, any case law on which you will be relying to, and you present your memorandum of law and an argument. So as we mentioned, it's a paper review process, mostly and only in exceptional circumstances it will be oral, and then the member of the Refugee Protection Division has the authority to allow the appeal, and by allowing the appeal they can substitute the decision with their own, so in effect granting the individual, the appellant, the convention refugee or person in need of protection status. they may quash the decision and send it back for redetermination by a new panel. They may dismiss it for lack of jurisdiction. So let's say, what can be lack of jurisdiction? It can be when you have no right of appeal, but you still file a notice of appeal to RAT, or dismiss if the appeal is not perfected. So basically, you do not submit the next step within 30 days. Or they may confirm the decision for the same reasons, so agree that the decision is correct, and the reasons, the rationale of the member of the RPD to reach that decision was correct as well. Or they may agree with a decision, but come to the same conclusion for different reasons. And so they may as well issue their own reasons as to why they came to that conclusion. Or if the appeal, or they may dismiss it if there is no credible basis. And then we have if the appeal has been withdrawn or the appeal has been abandoned. Now, the last one, which is, I'd say, the last division of the Immigration and Refugee Board, is the Immigration Division. Immigration Division hears matters relating to detention reviews and inadmissibility hearings. So on the detention reviews, the member of the Immigration Division is the one who is in charge of the hearing. And so the member will start by introducing himself and by presenting, I'd say, a synopsis of the situation. And so then the Minister's Council, always the most important hearing on the Immigration Division, especially on detention reviews, is the first hearing, in which the Minister's Council will provide a detailed account of the immigration history of the person concerned, of the person who is in detention. And so that way you will be, I'd say, fully informed as to what the issues are, what's at stake, and basically then try to determine as to what you need to do to secure the release of your client from detention. So generally, in terms of the timelines, the detention review here, I think that will come next. So let me finish this first. So we have the Minister's Council, who is commonly a CBSA representative, who will present the immigration history of the person concerned. And then you, as counsel for the person concerns, will basically explain your client's side and ask questions and try to make your case as to why your client is warranting of being released from detention. And then the member will evaluate that information and make a decision at the conclusion of the hearing as to whether to allow for the release of the individual or for the continued detention of the person. If the person is released, then the member will also impose terms and conditions on release, which are quite, I'd say, common to be imposed as well. Now, on the timelines, which are important on the detention reviews, you have, when a person is detained, the first, I'd say, a very important stage is because the timelines is within 48 hours or as soon as it is practically possible, the person concerned will be, or the case will be referred to the Immigration Division for a hearing. But once the person is detained by an immigration officer, there will be a review within the CBSA itself by a senior immigration officer as to the decision to detain the individual. And so in those cases, always keep in mind that depending, and again, that's not always the case, but depending on what's at stake, there is always a window for you to act and act quickly. So let's say if the person is detained because the officer is not satisfied of the identity of the person, now you can quickly fill that gap and submit evidence and supporting evidence to prove the identity of the person. And so in that case, you may be able to secure the release of the person without being referred to the Immigration Division. But once it is referred to the Immigration Division, then CBSA loses authority. They cannot release the person anymore, and a hearing will be held at the immigration division. So the hearing will be held, the first hearing will be held within 48 hours. Then the next hearing, assuming that the person is not released, the next hearing will be held within 7 days, and then it will be every 30 days subsequently. So assuming that the person is still there in detention, the immigration division will continue to hold hearings for that individual every 30 days for as long as the person is either removed from Canada or is released from the detention center. Now, in terms of, I'd say, the options or the vehicles that you have to secure the release of person, here is what you can present basically as an alternative to detention. And so what you can present a cash bond or deposit to secure the release of a person. Always, I'd say this is not determined by the nominal value of the money, but it is determined by a lot of other things and factors that come into play in that as well. That also performance bond, which is a guarantee of future payments should the individual not be able to, or the person to be released not be able to comply with the terms and conditions of their release. Now, if the member orders a performance bond, the bonds person must sign a document that is a promise to pay an amount of money in the future. And a bond is a payment or a deposit, a cash deposit that is made there on the spot to secure the release of the person. And so when I say that the nominal value in itself does not matter, always keep in mind that as an alternative to detention, you need to present a bonds person whom you also need to interview thoroughly and get all the information on employment and assets and family circumstances and more importantly, relationship to the person concerned as well. Because the whole purpose of alternative detention is to basically for a bonds person to be able to exercise a degree of influence on the person concerned on the person to be released, so that he or she will be able to comply with the terms and conditions of their release. And so the nominal value here is what I meant by this is that depending on the circumstances of the bonds person, let's say if you have someone who is making $150,000 a year and is proposing to put $2,000 as a bond, that might be quite insignificant compared to their income. But if you have someone who is making $20,000 a year, $2,000 might be quite significant and important for that individual to have an interest to exercise that degree of control and influence on the person concerned to be able to comply with the terms and conditions of their release. I think was about it. That's it for this presentation about, I'd say, overall immigration, what's new, and the IRB itself. And let's see if I'm open to any questions that you might have. And we take it from there, I guess.
Thanks so much, Arian, for sharing all that. Very informative. I do have a question here. I know you touched on dual licensees would have to potentially do the program. Do you know anything? I mean, if let's say a paralegal currently is able to do the stuff at the board without getting the RCAC license, do you know if that would be changed by the program if they're solely a licensed paralegal, or is that something that the Law Society would clarify?
I think that's something exactly. Yeah, that's something that the Law Society will clarify. And I was actually looking for the IRB, looking at the IRB itself to see if there has been anything to that effect on the part of the IRB, and there was nothing that I could find to this point. So as it is now, as we speak, only paralegals who are members of ICCRC or in the future of the College of Immigration and Citizenship Consultants will be required and will be mandatory for them to take the specialization program. And paralegals who are not members of the ICCRC, of course, the regulator ICCRC has no jurisdiction over them and cannot regulate them. So now I think it remains to be seen whether the Law Society itself will step in, or the IRB will perhaps come to that and implement certain policies or requirements to that, which in effect may as well force the Law Society to do something and implement perhaps a program or something along those lines. But that remains to be seen. For that part, for that group, nothing is clear yet.
Now, Arian, I have a number of students who are starting today. I think it's like their very first day, and some of them are almost finished. So kind of on both ends of the spectrum. I was wondering if you have, in terms of advocating, whether it's the Immigration Refugee Board, where, you have your wealth of experience in, and certainly you have time teaching as well. Maybe you can share just in terms of just general advocacy, some tips that have worked for you that you've shared as well with the students in the respective programs you've taught at.
Well, I'd say in terms of the key advocacy skills will always be to always what I used to tell my students when we would prepare or do a tribunal procedure. Always the key is in attending a hearing, the key is preparation. And on the preparation side, I will put it into three parts in itself. One is your knowledge as a professional, as counsel, about the subject, about the immigration topic on which, or refugee matter on which you are representing the client before the division, before the IRB. Then knowing in depth your client's case, the facts, the circumstances of your client's case, so that you are able to that way advocate on behalf of your clients and advance your client's interest and not leave, I'd say, any stones unturned on behalf of your client. And then the third thing will be to be familiar with the rules of each of the divisions, of the division you're going to. Like I said before, each of the divisions is considered to be a master of its own house and it has its own set of rules. And so you need to be familiar with that as well. And the preparation is always key, so that you, I'd say, when you go to the hearing itself, that is important. And I cannot, I'd say, I'm not, it's not fair to say that, yeah, that won't matter. But the most part of it has happened outside of that role. You thoroughly interviewing your client, preparing your client, questioning your client, grilling your client if that is required, if especially in adversarial hearing. Why? Because the other side, the minister's counsel or the opposing side, will not have any mercy on your client. So it's not any help, I'd say, or any purpose for you as counsel to pat your client on the back and say, yes, fine, read this, do this. But you need to prepare them for what's to come there, for that environment that they will get into the hearing room. And that preparation in itself will, as well, will come into stages, familiarity with the hearing room, because a lot of times, not a lot of times, always, I'd say, in humans, the uncertainty, the unknown is what creates them, what elevates them, their stress. And so prepare them for the hearing room. Even I'd say the simplifying it. Okay, here is, do a little sketch, a little drawing. This is the hearing room. This is where we sit. This is where you will sit. This is where I will sit. This is where the member will sit. Then get into preparation of the process itself, as to how the member will explain what will happen on the hearing, who asks questions first, what will happen next, and so on and so forth. So if you remove that, I'd say, that unknown stress, the stress of the unknown to them, at least they will feel better during the course of the hearing. And then it comes the preparation on the subject matter itself, the preparation in terms of, like I said, you grilling the client and doing the utmost to get to the bottom of it. And going to the hearing as counsel is also something that you need to be mindful of. You in there are someone, or our counsel to, I'd say, serves your client's needs and being paid by the client. But at the same time, you're also, in the same way as going to the court, you're an officer of the court. In there, you're an officer of the tribunal as well. So you have, I'd say, responsibilities towards the tribunal itself in terms of finding the truth and only pursuing. And so here we come also on ethical matters as well, which perhaps we don't need to go for now, but always pursuing what you truly believe to be, I'd say, the case, and all the arguments that you feel will be in your client's best interest. Always, I'd say, final note on this is that between you and your client, when you go to the hearing and you walk out of that hearing room, if you walk out of it with no regrets, that basically you did all that you could and there was nothing else that you could have done any better, then the rest is on the decision maker. It doesn't mean that you always get positive decisions, but as long as you have that satisfaction that you did what you could, then you will feel good about it. And always there is room for improving, for honing those skills to do better with every time that you go there.
Perfect. So thank you, Arian, for taking the time here and joining
You're
us
welcome.
today and sharing everything. Just wondering, you could end with any final words of wisdom there. Again, I have students who are just starting with their paralegal program today. So anything about what the future may hold in the profession and the legal profession. And thanks again for taking the time to share all that information with us.
Thank you very much. It was a pleasure. And I wish the ones who are just starting I'd say the best in this program that will be fulfilling for you, and it will be fulfilling to also be able to serve others in need. And so hopefully you will have the drive and whatever it is that it's required to succeed in the program, but also to succeed in life. And always believe in yourself, because others have done it before and you can do it too. Always do the work, put the effort, and believe in yourself, and you will get to where you want to get.
Perfect. So take care. Thanks, Arian, for
Thank
joining
you.
us.